Hi, my name is Jessica Gagne, and I'm a child protection and family lawyer based in Toronto, Ontario, Canada. And today we're going to talk about child protection appeals in the province of Ontario. So these are appeals under the Child, Youth, and Family Services Act. And I'm going to be speaking primarily from the perspective of a lawyer who is representing a parent in litigation against a children's aid society. There are very few child protection appeals in the province of Ontario. These are statistics that I put together based on the reported decisions in child protection appeals over the 2020 calendar year. So in a unified family court decision, the first level of court in a child protection proceeding is the Ontario Superior Court of Justice. But in a non-unified family court jurisdiction like Toronto, the first level of court is the Ontario Court of Justice, where the appeal lies to the Ontario Superior Court of Justice. So in terms of how many appeals were advanced at the Ontario Superior Court of Justice in 2020, there were a grand total of 11, and 8 of those were appeals brought by parents, 2 were appeals by the Children's Aid Society, and 1 was an appeal brought by the Office of the Children's Lawyer of Ontario. So not too many appeals at the Ontario Superior Court of Justice, but actually things get worse at the Ontario Court of Appeal, where out of 864 published decisions, 4 of them were appeals of final orders of the Superior Court of Justice heard on the actual merits of the appeal. All 4 were parent appeals. 1 was allowed, 1 was partly allowed, and 2 were dismissed. So why are there so few of these appeals in Ontario? Why are so few parents appealing these significant orders that are being made that involve their families and that involve the permanent removal of a child from their care and possibly, the cessation of access that they enjoyed prior to the release of a final decision? My theory is that the reason why there are so few appeals is because the appeal funding system is broken, and there are very few lawyers as a result who are willing to do this work because of the lack of funding that exists. So I would say that based on my own experience, 95% of parents who are involved in the child protection legal system in Ontario rely on legal aid funding in order to have representation. Very, very, very few parents can afford a lawyer at first instance, much less on an appeal. So let's talk about how the funding procedure works for these child protection appeals. The first thing that happens is that the client gets a copy of the final order, the judge's final order, and contacts Legal Aid Ontario to obtain what's called an appeal opinion certificate. Now, these are quite readily granted by Legal Aid Ontario, so actually getting the appeal opinion certificate is not usually a problem. Usually these are granted same day or within a day of the client's request. Problem is not getting the appeal opinion certificate. The problem is what the appeal opinion certificate provides. So it provides 3 hours of lawyer time for an appeal opinion for a Superior Court of Justice appeal and 6 hours of lawyer time for an appeal opinion for an Ontario Court of Appeal. And so the client has to find a lawyer who will acknowledge their appeal opinion certificate and then do the following things: read the judgment once, twice, 3 times, speak with the client and trial counsel with a view to identifying potential errors of law. And yes, I recognize that you can appeal errors of fact and errors of mixed fact in law, but it's hard enough to succeed with an appeal that involves an alleged error of law, and it's almost impossible to succeed on an appeal that involves an error of fact or mixed fact in law, because the standard is much more deferential for those latter two towards trial judges. Whereas with an error of law, no deference is owed. The appellate court, has to set out what the correct legal principle or legal test or legal interpretation is. And it's not easy to read a judgment and identify errors of law, because trial judges don't, point that out. They write their decision as though everything that they're saying is correct. And it takes, critical thinking and often some legal research in order to figure out whether there's any merit to a potential appeal. So the lawyer determines all of this and writes an opinion letter to Legal Aid Ontario, submits it through the portal, but I also always fax it. Better to send it in 2 methods so that it doesn't get lost. And then the lawyer also has to assist the client with a fee waiver application, so that when the lawyer goes to file the notice of appeal and the certificate respecting evidence with the appellate court, the client isn't charged a notice of appeal filing fee. And the problem for lawyers is that if you skip that step and send your process server to file the notice of appeal and incur, I think, the $220 cost, and then you disperse that as a disbursement, as you expense it as a disbursement to Legal Aid Ontario. Legal Aid Ontario's policy is that you shouldn't do that. And if they find out you did that, they will claw back that money. In other words, the appeal filing fee will come out of the lawyer's personal pocket. So you don't want that to happen. You got to do the fee waiver application, send it in at the same time as your process server is going to file the notice of appeal, and you should be fine. And you're doing the notice of appeal and the certificate respecting evidence in the client's name only. In other words, you're not putting your own information down as counsel of record, because you don't have funding for the actual appeal yet. All you have is funding for the appeal opinion. So I just want to point out that trial counsel can do all of this too. They can acknowledge the appeal opinion certificate, they can write the appeal opinion letter, and it doesn't mean that they have to actually be counsel on the appeal itself. So I would encourage trial counsel to do this part, mainly because they know the case so much better than any other lawyer coming in would. And any other lawyer is getting paid for 3 or 6 hours to do all of this work. And if you've guessed that that's not enough time to do all of this work, you are absolutely right. It is not. So after the lawyer has submitted the appeal opinion letter, then you just wait. You can't order the transcript. You can't do anything. You just wait for Legal Aid Ontario's funding decision. And that can take a few weeks. It can take up to a month. As far as I know, there's no set timeline within which Legal Aid Ontario has to provide a response. If Legal Aid Ontario decides to grant funding, the tariff is 16 hours of lawyer time for a Superior Court of Justice appeal, not including the actual time spent arguing the appeal. And it's 27 hours of lawyer time for an Ontario Court of Appeal. Sometimes legal aid will deny funding, and sometimes they'll ask for more information before making that decision. If the Legal Aid Ontario's office has denied appeal funding, then you can appeal internally within Legal Aid Ontario to the district office within 7 days of receiving the first appeal funding decision. There's no additional tariff granted for council's time in doing this. And the biggest problem is the amount of time it takes to be made aware of the district office's appeal funding decision. So it can take up to 2 months to get this funding decision. And if that funding decision is denied, the next and final step that a lawyer has, apart from just deciding to do the appeal completely pro bono, is to bring a GJ or JG motion for state-funded counsel. So that's based on a Supreme Court of Canada decision. And there are very few motions for JG funding for CYFSA appeals that have been brought in Ontario. I brought one in 2018, and the case name is there. It was successful. But so it was successful, and I should say, like, Legal Aid Ontario does not pay counsel to bring the JG motion. They're done. Legal Aid is done once they've denied funding at the second level. So then at that point, you have to serve the Attorney General of Ontario and all the parties, and you bring your motion for state-funded counsel, and nobody is paying counsel for the time spent doing that. But it's an open question as to whether or not costs can be awarded against the Children's Aid Society in an appropriate case where they opposed a motion for JG funding. So in my case, the Children's Aid Society was ordered to pay my costs of bringing that motion for JG funding. And the Children's Aid Society appealed, not the order to provide state funding, because that does not come out of the Children's Aid Society's budget. They appealed the cost order that was made against them for opposing the motion for funding. And that decision remains under reserve by the divisional court. So we don't yet know the outcome of that. It's a bit of an open question. Whether and how counsel gets paid for time bringing a successful JG motion. Unfortunately, we have these impossible timelines that are set out in the family law rules and the CYFSA with respect to CYFSA appeals. And the reason why we have these impossible timelines is because the branch of the state that has created and made these timelines isn't communicating with the branch of the state that is actually funding these appeals. And so you have this disconnect. One of the rules that it can never be met is for an LAO funded appeal. You might need it if the client can afford to pay you privately, but I mean, almost none of them can. So the deadline that you're never going to meet is that you have 30 days to order the transcript from the date you filed the notice of appeal. Well, you're unlikely to even have the first funding decision by then from Legal Aid Ontario. And even if you got the first funding decision and they said, yes, here's your 16 hours or here's your 27 hours, you then need to write to them to seek authorization for the transcript disbursement, because transcripts cost thousands of dollars. And as a lawyer, you don't want to engage a transcriptionist and potentially be personally on the hook for thousands of dollars if Legal Aid Ontario isn't going to pay for the transcript. So you need to write to Legal Aid Ontario, ask for authorization to order the transcript. Now, it often takes a few weeks up to a month to hear back from Legal Aid Ontario with respect to the transcript disbursement authorization. And once you have that, then you need to go online to the list of authorized court transcriptionists that is maintained by the Ontario government. And you need to go through the list and contact and find a transcriptionist who has the bandwidth to take on the typing of your transcript. And Legal Aid Ontario does not pay for expedited transcripts. So that means that you're going to be probably waiting at least a month up to 2 months to get a copy of the transcript, depending on how long it is. There's another timeline set out in the rules that you have 14 days to perfect an appeal if there's no transcript required. It would be very unusual to not require a transcript for a first appeal. By the time of the second appeal, if your first appeal is to the Superior Court of Justice, by the time of your second appeal to the Ontario Court of Appeal, you'll already have the transcript, so you won't have to wait on it. So in that situation, you've got 14 days to perfect the appeal. After filing your notice of appeal, you won't even have the result of your appeal opinion certificate by that deadline. And then another very important timeline, which can be met, is that you have 30 days to perfect the appeal from the date of the transcript being ready. So you better hope it was a short trial transcript, because if you have 20 days of trial transcript to read, in addition to putting together the appeal record, which often number in the hundreds if not thousands of pages, and you have to do the book of authorities, which may have in highlighted, etc., format everything. I mean, you're definitely gonna want to set aside a chunk of time to get all of that done within the 30 days. So meanwhile, what should you do while you are waiting for these various authorizations and decisions? You should let the Children's Aid Society know of the status of your Legal Aid Ontario funding requests. And you're doing this in the hopes of avoiding having to respond to a motion to dismiss for delay. If the Children's Aid Society has no idea what's happening, they may just assume that the client hasn't been able to find a lawyer, is not moving forward with their appeal, and then they may bring a motion to dismiss for delay so that they can, finalize things on their end. So in my experience, if you do advise Society Counsel what's happening and what the delay is being caused by, then they're often not going to bring such a motion to dismiss for delay, because if it's systemic reasons, they're not going to succeed with that motion in any event. So it is scary for a lawyer to acknowledge, and what acknowledge means, it means accept. Like on the Legal Aid Ontario system, you actually have to acknowledge, which means accepting the certificate once it's been issued. And it's scary to do this for like a 16-hour Superior Court of Justice certificate or 27-hour Ontario Court of Appeal certificate. And the reason is because, according to the Legal Aid Ontario Tariff and Billing Handbook, you may not quit a case because it is complex and you do not believe the tariff is adequate. If you accept the certificate, you are expected to deal with all of the client's legal issues relating to the authorized proceeding. So if you have a 5 or 10 or 20-day trial, the decision of which is being appealed, and you've got a 16-hour certificate that is supposed to be enough time to read the trial transcript, do all the necessary research, draft the factum, prepare the book of authorities, prepare the appeal record, respond to any motions to dismiss for delay, bring any motion for access pending appeal. I mean, it's just not enough is the bottom line. and the funding model just doesn't make a lot of sense. So for example, like why is it a 16-hour certificate for a Superior Court of Justice appeal and a 27-hour certificate for the Ontario Court of Appeal when the amount of work involved is more for a first appeal than it is for a second appeal? Because for a first appeal, you're doing the appeal record, the fact in the book of authorities. For a second appeal, you've already got those documents and they probably just require some tweaking in order to file them on a second appeal, as opposed to starting from scratch. So it's a lot less work to do a second appeal than it is to do a first one. And the other thing is that these certificates are the same number of hours, whether you're an appellant on the appeal or whether you're a respondent, even though the filing requirements are much heavier for an appellant. They're the ones that have to prepare the 100 or 1,000-page appeal record, whereas the respondent often just has to file a factum. So it doesn't make sense that it's the same number of hours, whether you're the appellant or respondent. It doesn't make sense that there are more hours for the Ontario Court of Appeal. These are just some of the issues with the system. So I touched on this briefly already, but there are certain motions pending appeal that may arise. There's the motion for a stay pending appeal, which is almost never going to happen. And the reason I say it's never going to happen is because there's an automatic 10-day stay that is set out in the CYFSA. But the idea with that is that the 10-day stay grants either side enough time to bring a motion for a longer stay pending appeal where the circumstances justify. But in reality, parents will never have the funding in place to actually bring a motion for a stay pending appeal within those 10 days, or even within the time period that you would want to bring a motion for a stay pending appeal. There's also motions for access pending appeal. And this is very important because if, for example, the trial judge made an extended society care no access order that terminated the parent's access, and your appeal is on the issue of access, you don't want to go a year from the release of the trial judgment to the release of the appeal decision with your client having no access to the child. It just makes it all the more unlikely that access will actually be ordered by the appellate court. So it depends on what the society's position is. Sometimes especially for the first appeal, the society will maintain the access that was in place prior to the lower court's final order being made, or they'll reduce it, but they'll still provide some access to the parent. And then they won't stop that until an appeal decision is released, that affirms the trial judgment on the issue. But in other cases, the society will take the position that there should be no access pending appeal. And so they will, in other words, they will implement the trial judge's order on that issue. And in that case, you would want to bring a motion for access pending appeal. Again, this is theoretically supposed to be covered by the 16 or 27-hour appeal certificate. And then there's the motion for fresh evidence, which is very common in child protection. Often these motions are brought by the society. They can also be brought by the parent, but again, it's something where this is also theoretically covered by the appeal certificate itself. So from a parents' counsel perspective, bringing all of these motions essentially is pro bono work. There are some curveballs that can be thrown your way as appellate counsel. So, the Ontario Court of Appeal has a system where they automatically dismiss appeals for delay, including child protection appeals. They typically send out a warning letter, but then if the appeal is not perfected, then you get a letter saying it's been dismissed, automatically dismissed for delay. So this is obviously problematic when the delays are due to systemic funding issues and not the client or the lawyer dragging his or her heels. At the Ontario Superior Court of Justice, in Ontario, in Toronto at least, they will case manage the appeal, which means they have regular status updates scheduled where counsel provide updates and can set timelines. And I have before asked Society Council to be my agent for those status updates. So again, that just cuts down on the amount of time that needs to be spent by counsel, unremunerated time spent by counsel on these appeals. So let's assume you have successfully jumped through all of the previously mentioned hurdles and you have some funding from Legal Aid Ontario and you have your transcripts. Now it's time to perfect the appeal, which is somewhat funny language, but what it means is it means getting all of your appeal documents in and finalized. So that means the factum, that's where you set out all of your legal arguments, the relevant facts, the order you want the appellate court to make. You need to prepare the appeal book and compendium, which consists of a long list of things, a laundry list of things, but it's essentially all of the supporting documents that are relevant to the appeal. So the lower court's order, the lower court's judgment, documents that were before the trial judge and filed as exhibits, etc. And so my advice when it comes to these documents is to get samples from another lawyer who's done a child protection appeal and had their documents accepted by the court, because especially at the Ontario Court of Appeal, they are extremely precise, some might say finicky, about the formatting. And so you can have your documents rejected for the smallest of issues. And that's very frustrating and time consuming for counsel. So it's better to just get a sample, copy it to an absolute T. I should also mention that the forms at the Ontario Court of Appeal and the Divisional Court for child protection appeals are the civil forms, which poses an added challenge for lawyers in this area who are used to using the family law forms. So that's just something to know. You never want to wait till the last day to file your materials. You never want to wait till the second to last day to file your materials. You want to do this several days in advance so that if there's anything wrong with your formatting, you can fix it and still get it all in on time, because you do not want to have to bring a motion to extend the timelines. That's just going to take up way more time, probably unremunerated time. And so, yeah, you want to avoid that at all costs. So I've talked a lot about the challenges in the system, and now I want to talk about how we can make it better. And so, judges and Legal Aid Ontario and lawyers all have a role to play in this. With respect to judges, I I would submit that they should strive to understand the Legal Aid Ontario funding system for these CYFSA appeals. They should not chastise parents or parents' counsel for what are systemic delays within the Legal Aid Ontario funding system. The status update should be virtual always so that lawyers can call or Zoom in to provide the court with what are procedural updates between the time that the notice of appeal is filed and the actual appeal is argued. There should be electronic filing of materials always. This is something that has largely come about as a result of the COVID-19 pandemic, and it is one of the best things to happen to the legal system, and it saves so much time and so much money for everybody involved. And also, I think judges need to do whatever it is that they do that affects the court filing fees, because we need to eliminate court fees for CYFSA appeals. It makes no sense to not have any court fees at the Ontario Court of Justice, where all child protection cases in Toronto start, but then have these filing fees that just add another hurdle and another step at the appeal level. In terms of Legal Aid Ontario, there are several things that they can do to make this better. There are many opportunities for improvement. So first of all, we need set response times for funding decisions. I need to know how long it's going to take once I submit my request for transcript, disbursement authorization. I need to know how long it's going to take after I submit my appeal opinion letter to get a response on that. I need to know how long it's going to take if my appeal of funding decision has been lodged with the district office to get a response. We also need more hours on appeal opinion certificates. This is a bottleneck. Lawyers do not want to acknowledge these certificates because in order to actually do the necessary work, you're putting in pro bono hours for sure. There's no way that 3 hours is covering what's involved on that certificate. And those certificates, I mean, 3 hours it says on the certificate that 3 hours is also supposed to cover counsel's time in bringing a motion to extend the timeline if the client has surpassed the 30-day timeline for filing their notice of appeal. And I mean, really what that just does is it ensures that no lawyers are bringing those motions to extend the timelines because there's absolutely no coverage for it. We need a logical funding model. In other words, like a first appeal should have more hours allocated to it than a second appeal where you already have, a factum, a book of authorities, and the appeal record that are probably just going to need to be tweaked on a second appeal, whereas they had to be created from scratch on a first appeal. And we know that appellants have many more responsibilities in terms of the work that's involved with an appeal. They are the ones that have to prepare, 100 or 1,000-page appeal record. So the appellant should be receiving more hours on a certificate than a respondent, who often just has to file a factum, which largely consists of 15 pages of why trial judges are owed deference. So it doesn't make sense that both appellants and respondents are getting the same number of hours on a certificate. The other thing is that Legal Aid Ontario needs to promote better awareness both internally and externally regarding case management for CYFSA appeals. Case management does exist for CYFSA appeals. I've gotten it, but very few lawyers know that it exists and in fact are still being told by Legal Aid Ontario that it doesn't exist, because even within it, Legal Aid Ontario, staff are not aware. So Legal Aid Ontario needs to publicize that case management is available for these appeals, and lawyers need to tell each other that it is available. In terms of other things that lawyers need to do, I think that knowledge, basically precedent sharing between lawyers, is absolutely key. So in other words, sharing samples that you have of facta, books of authorities, although that's an easy one, and appeal records, just so that lawyers can see how it was done and how the formatting was done and copy it, and then not have to start from scratch looking at the rules and trying to figure out how it should look. And lawyers should push for positive change, because we are the ones who know the system intimately. We are in a much more empowered position than parents are. And it's our job to advocate for a level playing field, which is what the foundation of our adversarial system is. The playing field is not level, and it's our job to try to make it so. Thanks so much for tuning in, and I will probably be doing more of these CYFSA appeal videos. And so if you're interested, keep an eye out. Thanks a lot. Bye-bye.